Speaker.
Senator Sam Lotu-Iiga.
Thank you, Mr. Speaker, and it's a privilege to speak on this bill, the Electronic Transactions Contract Formation Amendment Bill, and I want to thank the member for bringing it into the House, Paul Goldsmith. He always makes thoughtful contributions both in Select Committee and to the House, and certainly this is another example of him making a contribution to our Parliament. So this bill is like its author. It's short, it's sharp, and it will have an impact on contract law and society in general. And this bill clarifies, sir, the legal position on the time at which a contract is formed if the acceptance of the offer is sent by electronic communication. Of course, contract law is one of the fundamental cornerstones of our legal system. Contracts facilitate trade, commerce, as well as other business and social transactions where they are proof of a transaction having taken place for a promise to fulfil a certain obligation or set of obligations. Sir, a contract is important as it protects both parties from any surprises or changes to contracts, and it helps the parties involved avoid any type of misunderstanding that may arise, and sometimes, indeed, contracts provide mechanisms for settling disputes that arise between parties. So a contract is an agreement which has a lawful object entered into voluntarily by two or more parties. Typically, each of the parties intends to create legal obligations or legal relationships between them. The elements of a contract, of course, are an offer and acceptance, normally between what would be considered competent persons who have legal capacity, who exchange consideration, and this, of course, can come in the form of money, where the terms of the contract between the parties must be certain. And contracts, of course, may be formed orally, by paper-based writing, through conduct, or through electronic means. So as explained in the explanatory note to this bill, sir, the general rule is that a contract is formed at the time the acceptance of the offer is communicated to the offeror. And we've already heard the rule in Adams and Lindsell that created an exception for acceptances conveyed by post. And basically, that states that when an offer was accepted by post, the offer was deemed to have formed from the moment the acceptance was posted, and not when the offeror was read by the contract was read by the offeror. So while the issue of whether the postal acceptance rule can be extended to electronic communications has not been considered by the courts, this bill ensures that that postal rule will not apply to contracts accepted by electronic communications. And I want to thank the member that's just sat down. He alluded to a difference between the different forms of electronic communications that may create some uncertainty around this clause. And I must say that also that the exception that was enunciated in Adams and Lindsell really was because when the defendant wrote to the claimant in that case offering to sell some wool, they asked for a reply that was, and I quote, in the course of post. So the letter that was ultimately delayed in that case was because the parties to the transaction actually required it as part of the contract to be in the course of post. So it's my view that the established rules around acceptance must still apply, and the factors that must be taken into account, sir, must be that the acceptance must be communicated to the offeree, the terms of the acceptance must exactly match the terms of the offer, and the agreement, as with any contract formed, whether oral or written, must be certain. So the general rule that the offeror must receive the acceptance before it is accepted has been stated clearly in the Torres and Miles Far East case, sir, where it was held that to amount to an effective acceptance, the acceptance needed to be communicated to the offeree, and hence where the defendant in that particular case sent italics, as as the previous speaker mentioned regarding telex messages, it was...
Sorry to interrupt the honourable member. His time has expired. I call Claire Curran.
Thank you, Mr Speaker. Mr Speaker, as you've heard tonight,